And just to say we're ready to go. Well, first I'd like to welcome everyone to this SDSMA Center for Physician Resources presentation on the medical malpractice lawsuit. The presentation is brought to you tonight in partnership with MMIC and is the fourth of 5 programs dedicated to risk mitigation. Please keep all lines open so you can as we go. If we do some background noise, I will go ahead and mute lines just so it's not distracting to the presenter. Shelley, I'm going to turn it over to you, Ms. Shelley Davis of MMIC, to introduce herself, and she's going to lead us through tonight's discussion.
Thank you. Good evening, everyone. Thanks for joining me. My name is Shelley Davis, as Mark indicated, and I am with MMIC. I am a lawyer and have practiced law for over 25 years.
Daddy, can I check it one time?
Hello?
Daddy, can I check it one time?
Okay, so we are picking up a little background noise. I think I will go ahead and...
Can we check one?
Hold on a second, Shelley.
Get the ice cream.
There, I think we have the background noise taken up. So please.
Yeah, good evening, everyone. Thanks for joining me. As I stated, I am a lawyer and have been with MMIC for just over 3 years. Prior to that, I represented healthcare providers for over 25 years when they were involved in claims, lawsuits, or adverse events. It is with pleasure I am talking to you tonight about how to protect yourselves as healthcare providers from being involved in, or worse yet, being named in a lawsuit. I would like everyone or anyone to ask questions at any time. I think you'll get out of this presentation as much as you put into it, so feel free to interject at any time. So the news for all healthcare providers is that statistically healthcare providers prevail when they are sued. And this is a significant higher winning percentage than any other type of lawsuit. And think about that, it's a pretty logical reason why healthcare providers win or prevail when they are sued. Everyone has in common the need for health care. Generally, healthcare providers, jurors are patients. They believe in and like their healthcare providers. And I think that's why statistically healthcare providers, when sued, do with their lawsuits. In other words, there is not a judgment against them. Let's talk a little bit about the elements of a medical malpractice lawsuit. A medical malpractice lawsuit involves negligence. Negligence is a tort. This is civil, not criminal. The proof is not beyond a reasonable doubt, but more likely than not. In other words, a jury has to be convinced that more likely than not, you as a provider were negligent in order for the patient or plaintiff to prevail. The patient is the plaintiff that sues the defendant doctor in medical malpractice cases. So what is negligence? It's an act or an omission that harms someone. Specific healthcare providers, failure to use the degree of skill and learning that's normally possessed and used by other healthcare providers in standing in a similar practice and under like circumstances. So that's the legal definition. That would be legal jargon. The common sense, day-to-day definition of negligence is the failure to use reasonable care. And what does that mean? That means you either do something you should not do, that's unreasonable to do, or you fail to do something that you should do that would be reasonable to do. And you always have to put it in the context of the specific patient you're taking care of and the entire clinical presentation of the patient at the time you are providing care. It's really easy to look at a case with a retrospectoscope and say, you screwed up. That is not what the jury gets to hear. to hear what you were thinking at the time you made your clinical decisions. That is what is looked at and determined whether or not it was reasonable or unreasonable. How do physicians get sued, and where do these lawsuits come from? They get sued, as I said, due to alleged negligence and the perception, and I emphasize the word perception, of poor patient care and or undesired outcomes. So sometimes this perception is accurate. Usually it's not. Usually it comes from somewhere, something someone said, something someone did, and I'm going to talk about some specific examples. That's a story about an architect that had to have some hand surgery, and the outcome was not outcome for the architect, and the architect sued the hand surgeon. What happened in this particular case is the care and treatment provided by that hand surgeon was reasonable and appropriate. It was actually the anesthetic that was used that caused some problems, but the problems that it caused were not unexpected. So an adverse outcome, and the architect sued, and the architect did not prevail because the surgeon was able to demonstrate that he reasonably and appropriately performed surgery. The anesthesiologist was able to demonstrate that he reasonably and appropriately provided anesthesia during the case, and more importantly, that what happened was a risk of procedure that was explained to the patient prior to having the procedure performed. A lot of people sue because they're angry. And anger, more often than not, comes from some sort of miscommunication between the patient and his or her provider, and or the patient's family member and the patient's provider. We can't control anyone else's behavior, but you are in control of how you respond to someone else's behavior. So a patient may be angry, as the architect was angry, about an outcome following treatment, even though the outcome was reasonable or at least met the standard of care. You know, loose lips sinks ships. That's very prevalent in medical negligence lawsuits. I know that I'm going to remind many of you to think before you speak, to things that you know you shouldn't do. Sometimes we, as health providers, do it anyway. So, if you will, getting on the elevator with a colleague, having a very tough day, and starting to talk about patients in room 7. It happens all the time. And in this, imagine that there is another person in the elevator that neither of the providers know, but you've had a rough day and you're kind of blasting the patient in 207. Well, guess who's in the elevator with you? It's going to be patient 207's loved one, some family member or whatever. And of course, that loved one knows what room his or her loved one is in. And that individual is going to walk away from that elevator talk, chat, if you will, and be upset about something that was said between the providers. And the providers didn't mean to infer that any care and treatment was unreasonable or inappropriate or that the patient was such, but those types of things happen on a regular basis. Other situations we see that are the impetus for lawsuits are when providers comment about another healthcare provider's care and treatment. That may be verbally, and unfortunately, it may be, and I have seen on numerous occasions, where it is in writing in the patient's chart. So my advice to every provider is to not comment about other healthcare providers' care and treatment. You were there, you don't know why the provider did what he or she did, and it is best to think that the provider did the best he or she could do based on the clinical presentation at the time the provider provided care and treatment. Now, that's a mouthful. The comments such as, oh my goodness, why did so-and-so do this? Oh my goodness, what happened here? It's those types of comments about another provider that get patients thinking perhaps the care and treatment they received was less than in the standard of care. Also remember that the standard of care is on a spectrum. Just because Dr. Jones would do something doesn't mean that that is the standard of care. The standard of care is on a spectrum. It is not what one provider would do. 2, think before you speak. It's a lot easier said than done. Think about how you say things to your patients, how you document your care and treatment, and remember to be objective. I would submit to you that the less adjectives you use in documentation, the better off everyone is. Objective, I'm thinking of a couple of specific examples. So if you have a very angry patient or a very angry patient's family member, instead of documenting a conclusory statement such as the patient was angry or the patient's mother or wife was angry, document what you're hearing, what you're seeing. Patient, raised voice, red in face, spitting while talking to me and in my face. That gets across what you want to get across without drawing a negative conclusion. Same thing in a situation where you think a patient or a family member is drunk. Instead of just writing that conclusory statement, patient was drunk, or patient's husband appeared drunk, document the objective findings. Patient had slurred speech, red eyes, smell of alcohol. That way, the jury gets to make the conclusion instead of you making the conclusion. The problem with you making the conclusion as the provider is the message you are sending or documenting is that you don't like the patient. And that's how that is going to come across to a jury as well as the patient. It's not going to allow the patient to like you, if you will. And if it does go wrong, it's more likely that you will be sued. Any questions, comments before I go forward?
What I'll do is I'm going to go ahead and I'm going to mute all the lines. I went ahead and muted them just because we did have a little background noise. So at this point in time, all lines are on mute.
You're going to go practice before you go to bed.
Kicking the pants.
See a kid do things on his own. Yeah. They think that he starts doing it on his own.
Okay.
Okay, we'll continue. So legal elements of a negligence claim or a negligence lawsuit. And there's a difference between a claim and a lawsuit. A claim may be brought by a patient. A claim may be brought by a patient's lawyer. All the claim is an allegation that you provided substandard care and a request for compensation. A claim becomes a lawsuit when you as a provider are served the legal papers called a summons and complaint. And the difference between the two is when there is a lawsuit, the court system gets involved and you are dealing with court deadlines, other kind. When it's a claim, it is your professional liability carrier that will work it up and make a determination how to handle after looking into the elements of a negligence claim and making a determination whether the care and treatment provided was reasonable and appropriate. So the first element of a legal medical malpractice claim is a duty. A duty has to be established. All providers have the duty to act within the standard of care to provide reasonable and appropriate care, again, based upon the entire clinical presentation of the patient. Next element is a breach of duty. In other words, you as a provider have to depart from the standard of care. You can provide unreasonable, substandard care in order for there to be a finding of a breach of duty. That to be causation. Duty, the breach of duty has to be connected to the plaintiff's claimed damages. In other words, there's a departure from the standard of care and causes the claimed damages. And of course, damages must be present. Many times there are situations where there is negligence, however, there are no damages connected to the same. and I'll give you an example of that in just a minute. So, standard of care, as I alluded to earlier, healthcare providers tend to believe if another healthcare provider provides care differently, that conduct is malpractice, and that is simply not true. The standard of care is always on a spectrum and always depends upon the specific patient's clinical presentation. So what does that mean? If you have a patient and you're going to make a clinical decision relative to diagnosis, testing, or whatever, if the fact that the patient has diabetes or cardiac issues comes into play and you do something different than you would normally do, you're still likely practicing within the standard of care, because standard of care always depends upon the specific patient's clinical presentation. Peers determine, and peers, those are experts. So if you are a family practitioner, if you are a neurosurgeon, if you are a board-certified emergency room physician, I'm going to get one of your peers to review your care and treatment, and I'm going to ask that peer of yours whether the care and treatment was reasonable and appropriate based on the entire clinical presentation at the time you provided the care and treatment. And your peers, and they're not your buddies or your friends, it's an expert of like kind that will explain to the jury that it's reasonable and appropriate. And it's the other side's experts, which are also your peers, that will tell the jury your care and treatment was unreasonable and inappropriate. Earlier as well, many providers think just because there's a bad outcome or an unexpected outcome, and that actually is correct, but just because there's a bad outcome does not necessarily equal bad care. And what we're seeing a lot of these days are lack of informed consent claims, and for some reason it just seems to be becoming more and more prevalent, at least over the past, I would say, 5 years. So one tidbit of advice I would like to share with you is that an ounce of prevention is worth a pound of cure. And some reason providers think it takes a long time to provide informed consent, and I submit to you that informed consent is not an 8x11 signed document indicating informed consent occurred. I would submit to you that informed consent is a work in progress. It begins at the initial visit with the patient, when you start talking about what you believe is going on with the patient, and your suggestions are relative to care and treatment. And progresses under care and treatment actually terminates with the patient. So be sure to spend the time to provide adequate informed consent. It doesn't mean that you have to document absolutely everything you have told the patient relative to adequate informed consent. If you don't document everything you've shared, you better be able to give me your spiel when I ask you, Dr. Davis, tell me what is your informed consent for this procedure. And you better be able to say, talk about this, and I talk about this risk, and I talk about options, and I talk about alternatives, and I talk about decision to do nothing and what the potential ramifications are of that decision as well. So consent goes a long way to prevent a successful medical malpractice lawsuit, and it goes a long way to help explain why the bad outcome was a risk or a complication of the procedure and a risk that the patient took on when he or she decided to move forward with that procedure. And have to suffer, as I said, an injury as a direct result of your departure from the standard of care. Then the patient must prove it was more likely than not that your negligence caused his or her claim damages. If you're negligent and there's no injury related to the negligence, the lawsuit will not be successful. A case where a patient came in and had sleep apnea and was be given a lot of pain medication because the patient was in a lot of pain, low pain. And ultimately the patient coded and died, and the plaintiff's lawyer thought that he had a very good case because he had pulse oximetric readings that were in the 60s and 70s for an extended time frame. The good news is there was also an addendum in the chart, and when I say the good news, I say the good news from a defense perspective. When they're doing the review of the chart, because again it was an unexpected outcome that this patient died, one of the reviewers saw oximetric readings in the 60s and 70s and called the nurse that was providing care during that time and said, "Hey, what's going on here?" And then explained that, well, the patient had on a pulse oximetric and was banging his hand against the side rail, and that was causing inaccurate readings on the pulse oximetric. So the reviewer asked the nurse to add an addendum to the chart, and that nurse was deposed shortly thereafter. The case went away. So again, there may have been some negligence in that situation, but it certainly did not cause the patient's death in that case. So how do you protect yourselves from lawsuits? A lot of doctors will get a request from the Board of Medical Practice or a request from the patient's lawyers to write up opinions about care and treatment, or a request about custody issues relating to their patients. All sorts of bizarre requests come from patient lawyers. And I would submit to you that what you do with all of those is you hand off to administration and be short-sighted and try to take care of those types of situations for yourself. A lot of times physicians will think that, hey, if I just write this letter that the patient is asking me to write, or these questions that the patient's lawyer is asking me to answer, I will get this off my plate. In other words, as or healthcare providers, you tend to be task-oriented. So if you can get this task off your plate and done with it, things are over. And 99% of the time, your involvement in the patient's legal matters is just beginning. The next thing you know, the patient's lawyer is going to get involved, or the patient's lawyer is going to ask you to provide opinions, answer a bunch of questions, and the next thing that will happen is you will be asked to show up in court and testify in accordance with your opinions. And you do not have to do these things. There are ways to avoid getting involved in your patient's legal matters. And the way to do that is to hand off those requests to administration and have administration tell the lawyers that you are not going to be involved in your patient's legal matters. Your relationship with your patient is as a health care provider, and that's the relationship you have and you want to preserve, and the patient's lawyer should get someone else involved relative to the patient's legal matters. As far as answering Board of Medical Practice letters on your own, I said to you that it's good to get your professional liability carrier involved for the same reasons I said about a patient's lawyer asking you questions, and that is you don't want to rush and send something off to the board without being thoughtful, because the next thing that will happen if you're not thoughtful is that the board will ask you to come down and have a conference with you, and it may be a bigger deal. So always get your administration involved when legal things come up relative to your care and treatment, and get your professional liability carrier involved so that your professional liability carrier can help you respond to board requests, adverse events, unexpected outcomes, and any court letters from any patient's lawyers. And thoughts or questions at this point in time? We're about halfway through. I don't know, Mark, if you want to.
All the lines have been taken on mute, so any questions for Shelley this time? Oh, Shelley, hearing none, go ahead and proceed.
Okay. So let's statute of limitations, or in South Dakota, it is more specifically called the statute of repose. An individual or a patient has 2 years to bring a medical negligence cause of action from the time treatment ceases. And I believe that this next bullet point is inaccurate, and that it may be, even for a wrongful death claim to be brought, it is 2 years. May be up in the air. I would ask your South Dakota lawyers what the answer to that question is, but I believe it's also a 2-year statute of limitations for a family member to bring a wrongful death cause of action from the date of death. Where treatment of children are involved, the statute of limitation varies. The rationale for that is they want to give the plaintiff the opportunity to make sure any and all claims relative to the negligence can be figured out, any and all damages can be figured out, so that does vary. And the patient's failure to file a lawsuit does not preclude the statute of limitations or statute of repose from running. In other words, it is the patient's obligation to bring a medical negligence suit within the statute of limitations. And if the patient fails to do so, fails to get representation, then there is not going to be a successful lawsuit. Talk about documentation and the importance of the same. So a lawsuit, even though a lawsuit is brought within the reasonable amount of time, within 2 years from the alleged negligence, a lawsuit still may not get to court for years. So backlogs of cases, discovery processes, the criminal cases have priority, so your case, a medical negligence case, could get bumped, could be all set to go and get bumped off the trial docket. It's likely that you're not going to remember your patient. So, of course, the patient's theory or the plaintiff's theory is that he or she recalls everything that happened because it was the most dreadful, most horrid, most gruesome experience that that particular patient ever had. So what to defend yourself when you don't remember the patient? You have to rely on your charting. So it's the documentation that is imperative, and I know that many providers continue to be very frustrated with the EMR. It's here to stay, so we have to work with it. And I suggest to you that you are very careful and very specific in your documentation, because what you're going to get to review when you do get sued, and you're going to look at your charting and say, I can't believe I didn't document this. I usually document this type of thing in this type of case, and I didn't do it here. I'm not quite sure why it is. So keep in mind when you're thinking that it's very time-consuming to document. It's number one. And number two, it's the only thing you have to rely on when you go back and you look at your care and treatment. We have in the medical negligence world, for defense, I will refer to as standard operating procedure. The plaintiff's lawyers would like you to think that if it's not documented, it hasn't been done. And that is absolutely not true. Lawyers do not document everything they do. There are many things that documentation infers automatic conduct, automatic standard practice. So it's okay if your documentation means specific conduct to you, as long as you're able to recite whatever that specific conduct is when you are involved in a medical negligence lawsuit or claim. So, EMR pitfalls. I'm sure that many of you are aware of some of the issues, or many issues with the EMR. So the EMR has not fixed all the issues relating to documentation. In fact, it's created additional issues related to documentation. It's more spots in paper records, and a lot of times it's limited to the filling in of templates and the checking of boxes without the use of a narrative. I think we've gotten better as far as the use of narratives is concerned with EMR, and I would encourage you, if things do not fit in the boxes, to be comfortable to use the narrative. So some bad grammar in the EMR lead to the same conclusion they did on paper: sloppy and substandard care and treatment. Unapproved and or personal abbreviations, not good, mean that these mean different things to different people. Fatigue is now an issue. So providers will overwrite alerts because they just want to get to the end and finish their documentation. I just had a case where a nurse was tending to a patient, and the patient was having pain. The nurse was relieving another nurse for lunch. Because the patient was having a lot of pain, she just called up the provider and said, "Look, I'm going to give this patient some Toradol. Is that okay with you?" The provider said, "Sure." Instead of going to the EMR and documenting the order, the nurse did a reasonable thing. She went and gave the patient the Toradol because she wanted to relieve the patient's pain. And then within a minute or two, she went to the EMR to enter the order and saw, to her horror, the patient was severely allergic to the medication Toradol. So she's trying to do the right thing, to tend to the patient first and do her documentation later. And the situation, it wasn't alert fatigue, but there was an alert available, and she missed it because she didn't follow standard operating procedures before giving the medication Toradol to the patient. Fortunately, they were able to tend to the patient immediately and prophylactically intubate the patient so that patient's airway did not close. The patient did end up staying in the hospital for 5 days, where she came in for an outpatient procedure, which was a terrible situation. And there are reasons to follow policies and procedures, to not disregard alerts simply because you want to get to the end of your day, you want to get to the end of your documentation. Cut, paste, and carry over issues. This is something we're starting to see becoming an issue. A lot of providers will just cut and paste and bring someone else's history and physical over and adopt it as theirs. It is not a good idea. The patient is being seen or still an inpatient because the patient needs to be, and you need to do your own assessment of the patient. Using someone else's is not a good idea, and it's pretty obvious when you're looking at the record down the road. Template, same issue. If the template doesn't fit, don't use it. And then, of course, there's the failure to have any real interaction with the patient because you're so concerned about your documentation that you come in, greet the patient, hopefully, but then down, turn your back to the patient, and are typing away as you're asking questions rather than having that interaction with the patient and simultaneously looking the patient over as you're having that interaction. You lose that if you're typing away or have turned your back to your patient and instead are typing. A situation where my mother had some surgery done, and the home health nurse came over to assess her. I can't remember what post-op day it was, maybe 5 or 6. And the entire time the nurse sat across from my mother but had her head down and was typing. And my mother is Caucasian and is about 5'3" and weighs about 130 pounds. And when my mother was answering the questions this nurse was asking, my mother could have told this nurse she was 130 pounds and African American, and I'm certain that would have gotten into my mother's chart because the nurse was so concerned about getting the documentation done, she wasn't paying any attention to the patient. Addendums. Your facilities that you're at should have some policies and procedures about addendums. I submit to you that addendums are a good thing. If you omitted something you believe is pertinent to your care and treatment, perhaps you made an error in your documentation, you should correct it as soon as possible. You should correctly identify your addendum as such, in other words, an addendum or it's a late entry. And I would submit that your facility should have some sort of policy in place that should be reasonable and appropriate as far as addendums are concerned. I gave one example, the pulse oximetry. I'll give you another example. I was working with two surgeons taking care of a patient, and one went in, or one was the primary surgeon, and performed a surgical procedure. Guy did not find what he expected to find and had to do all sorts of machinations surgically. And surgery went well. About an hour later, the patient coded, and the primary surgeon as well as the assistant went in and helped with the code, helped with taking care of the patient hours later, and they realized after all of that that they did not document anything of their care and treatment during the time frame. So they called and asked whether or not they should document something relative to their care and treatment. And of course the patient died, which was an unexpected outcome relative to the anticipated surgery. So we worked through how that addendum should be drafted and decided that it would be a summary addendum, and the primary surgeon would go back into the chart, indicate that it was a late entry, but actively document what transpired, because he knew if there was a lawsuit that it may not come to be for a couple of years, and the surgeon would not have the memory he had within 24 hours after the incident road. So he did put in a summary addendum. So again, I would submit to you that addendums are a good thing as long as they are not CIA addendums, but should be reasonable, appropriate, related to care and treatment, and objective as possible. And if the facilities you're at discourage you from drafting addendums, I would argue that that is not a good thing for you. Okay, object charting, we talked a little bit about this. Here's a couple of additional examples. I see many times still, foot looks good, foot looks worse, those types of things. You care providers, you have medical education, your extremities do not look good or worse. Your extremities are pink, they have capillary refill, they're warm to touch. That's the type of terminology that should be in your documentation. Again, objective, factual, so that it means something. If you think about it, the chart is the tool of communication. It allows one provider to look at a broad spectrum of care and treatment and determine what has happened and more importantly, what should happen next. And a couple of additional examples related to conclusions such as patient appears intoxicated, patient is angry, obnoxious, and I already addressed this a little bit, what objective should be in support for any conclusions, if any conclusions are documented. People limit the use of adjectives. I shared that as well. So texting is a very big issue in providing care and treatment these days. At this point in time, the Joint Commission is telling us that it's not acceptable for physicians or any licensed independent practitioner to text orders for patients to the hospital or healthcare settings. And now for this is there's no method to provide the ability to verify the identity of the person sending the text, and there's no way to get it into the chart. I think we're working on this. Photographs are another thing. A lot of people are taking pictures of things and sending them in, and I think it's fine as long as you can discern what that picture is. That picture is telling you. You cannot figure it out if it's just a bad photo. They need to tell that patient he or she needs to be seen somewhere, regardless of the inconvenience to do so. So until we get to the point where we are able to get the text into the chart, I know some facilities are giving providers phones, and that phone would belong to the facility. And arguably, any texting messages would be incorporated into the patient's chart somehow. I'm not quite sure how, but we're getting closer to having texting be something that would be considered reasonable to do, unreasonable. The thing I want to talk about here is termination of care. You as a provider have the right to terminate care and treatment at pretty much any time for good reason. So I would submit to you that your facility should have policies relating to terminating care and treatment. You can terminate for non-compliance, unreasonably demanding, or anything that would support, and this is key, a breakdown in the patient-physician relationship. So sometimes providers are fearful, and you should not be. I wanted to make sure that you were reminded it is reasonable to terminate your physician-patient relationship when a breakdown in that relationship. Termination is when you terminate at an unreasonable time without giving the patient the chances to find an equally qualified replacement. The AA basically says you need to provide written notice, send certified mail. You need to provide a brief explanation for terminating the patient-physician relationship, and you need to agree to provide treatment while the patient finds a new provider, and of course for emergency situations, and need to provide resources and or recommendations for a new provider. And you offer to transfer the records with the appropriate release of information form. Questions on any of these issues? Mark, unmute.
Give me just 1 second here. And at this time, all phone lines have been taken off mute. And so if you have any questions, Kelly, please ask.
My name is John Schulso. If for a bad outcome, if you put your recollection in the record, but then over the next several weeks to months, remember more things, you keep a personal recollection. And where does it legally fall?
Sure, great question. You can do anything you would like. I think if there is a bad outcome, that the facility should stand behind you and open up a file, if you will, where things like your memory, your documentation of your memory as it comes to you may be kept so that that information is protected down the road. A lot of, I don't know if South Dakota has an apology law or statute. I didn't look that up before this presentation. MIC has a position statement, apology, and communication. We also have draft exams for providers, for facilities, and any MMIC has access to all of this information. So the general suggestion is that you tell the patient and or the patient's family members what you know at the time. And the problem with documenting what you think happened immediately after an adverse or unexpected outcome is that may be inaccurate. So I think best practices would dictate after a bad outcome or expected outcome, that documentation really relate to, one, you want to take care of the patient first and make sure the patient is going to be okay medically. And then number two, participate in an investigation to determine what most likely happened. And the reality is we don't always know what happened, and we won't always find out definitively what happened. But I think what is important to let the patient and or the patient's family members know is what you know at the time. Number one, you're going to perform an investigation to see why this happened. Number two, you're going to keep the patient and or the patient's family member informed, you know, when you know it. And what providers have a tough time doing is saying to the patient and or the family members is these three words, I don't know. And I would submit to you that it's better to say, I don't know. We're going to look into it, and we're going to tell you what we think happened or what really did happen when we find out. So that was a mouthful of a response, but I do think it's imperative to make sure that you don't document or don't tell patients or patients' family members something we're not pretty doggone sure that that's what happened. And keep in mind that it's okay to say, I don't know, but we're investigating. Answer your question?
But if you keep your own diary of stuff,
yeah,
where is discoverable?
Yeah. It's going to be discoverable in 99% of the states. It's related to patient care and or an investigation related to an adverse or a bad outcome. Your facility should have some sort of process in place to allow you to be able to document those types of things so that they are protected. I would not keep a personal journal. I mean, it will be discoverable if there is a lawsuit. I can't imagine a state where something like that would not be discoverable.
That's what I thought.
Any other questions?
Answers for Shelley at this time? Okay, Shem, do you want to continue?
Yeah, I'll continue with my my disclaimer and let you know that it was a pleasure speaking tonight, and if you have any follow-up questions or issues, you certainly can contact MMIC, and the contact number is on this last page, and I thank you for your time.
Well, certainly appreciate you taking time to be with us this evening. Some questions have come in, basically come to us after these presentations have been over. So would it be okay with you if I forward them on to you or someone at MMIC?
Feel free to forward them on to me. It would be my pleasure to respond.
Okay, great. Again, we do appreciate you taking your time this evening. For those on the call, I do want to remind you that there is Category 1 CME credits available. To close out of the session today, it should take you to the website over at the medical school, and you need to fill out a form there, but you are able to get Category 1 CME credits for participating in tonight's presentation. And with that, I also want to make a note of that the next presentation is scheduled for Tuesday, September 13th. That last program of this series that we are doing with MMIC, and that evening will be physician resiliency and healing the healer. So I do thank you all for participating this evening and wish you all a good evening.
Good night.
Thank you.